The Jeffrey Epstein case is no longer just a criminal file archived in a courthouse basement. It has become a structural case study in the fragility of justice itself. For decades, the allegations existed in whispers, fragmented stories from vulnerable young women, overshadowed by a financier whose wealth bought not only access, but insulation. What began in the early 2000s as isolated reports has, by 2026, evolved into a sprawling international scandal that forces us to confront an uncomfortable truth. Power did not merely influence the system, it embedded itself within it. As millions of pages of once sealed federal documents continue entering the public domain, the case reveals something deeper than individual criminality. It exposes how institutions can bend, delay, and deflect when confronted with elite misconduct. This is not simply the story of one predator. It is the story of a network and a system that struggle to confront it. Let's talk about how a sweetheart deal nearly ended the case. In 2008, a federal investigation into sex trafficking concluded not with sweeping indictments, but with a negotiated plea agreement in Florida. Jeffrey Epstein pleaded guilty to reduced state charges of solicitation. The sentence: 13 months in jail, much of it served under work release privileges. Behind the sanitized language of the agreement was a vast trafficking investigation that never reached federal trial. The non-prosecution deal shielded potential co-conspirators from exposure and halted broader inquiry. For nearly a decade, the case appeared dormant. Then investigative journalism intervened. In 2018, renewed reporting dissected the 2008 agreement, revealing procedural irregularities and sealed communications that reignited federal scrutiny. Without sustained media investigation, the 2019 federal arrest might never have occurred. The lesson is stark. When negotiations happen in darkness, accountability often becomes negotiable. The release of documents in 2025 and 2026 produced a catalog of names spanning politics, business, academia, and diplomacy. Flight logs, contact books, social photographs, email exchanges. But proximity is not proof. A critical distinction must remain clear. Being named in documents or appearing in flight manifests does not equate to criminal culpability. Many individuals referenced in the records have not been charged with crimes. Some appear due to professional roles, social intersections, or peripheral contact. The tension lies between public knowledge and prosecutable evidence. Transparency reveals association, but the burden of proof in court remains high. In high-profile investigations, reputational consequence often arrives long before legal conclusion. Epstein's operations extended beyond New York and Florida. His private island, Little St. James, became emblematic of exclusivity and secrecy, a secluded node in a network that crossed borders. The international dimension of the case underscores its scale. Diplomatic and financial circles in Europe faced scrutiny over past associations. Institutional reputations were challenged. Careers were disrupted. The implications demonstrate that this was never a localized scandal. It was an ecosystem of influence, where social proximity to wealth granted entry into elite circles that often bypassed conventional accountability. When political figures, financiers, and diplomats appear in overlapping records, the case shifts from criminal narrative to geopolitical study. Epstein's 2019 death in federal custody officially ruled a suicide, ended the possibility of a criminal trial against him. In his absence, accountability centered on Ghislaine Maxwell, his longtime associate. Her 2021 conviction for sex trafficking minors resulted in a 2-0-year federal sentence. For survivors, it marked a significant legal acknowledgement of wrongdoing. Yet, the conviction also underscored an uncomfortable reality. Prosecutions in elite trafficking cases often reach enablers before they reach broader networks. Maxwell's sentence provides resolution in part, but not total institutional closure. The larger architecture of influence remains largely untested in court. With criminal proceedings against Epstein concluded by his death, survivors turned to civil courts. Litigation against his estate and associated entities continues to shape the final chapters of the case. Meanwhile, the ongoing release of federal files presents a modern ethical dilemma. Transparency is essential in trafficking investigations. But document dumps also expose peripheral names, staff members, incidental contacts, and individuals never charged. The digital age magnifies association. A name in an archive can become a permanent search result regardless of legal outcome. The public's right to know now collides with the individual right to privacy. Justice in this context becomes not just a legal question, but a societal one. The Epstein case stripped away the illusion that justice is automatic. From the 2008 plea agreement to the 2026 document releases, the through line is persistence by survivors, by journalists, and by investigators. It reveals a system where influence can delay consequences and silence can be negotiated. As the final records surface and civil cases move toward resolution, one question endures. Can a system built and sustained by power truly hold that power accountable? The Epstein case is not a closed file. It is an ongoing examination of institutional resilience and its limits.